Hey everyone, it's Mr. Drake. Today's video is a very short overview of how a case in the federal court system can make it to the United States Supreme Court. What we'll look at in this video is the actual procedure for a case getting to the court, and also the reasons the Supreme Court may take a case, because as we'll discuss, the Supreme Court touches only a very small fraction of the petitions to hear a case that it gets every year. You should be able by the end of this video as well to identify these terms: stare decisis, a writ of certiorari, or cert for short, the rule of four, and oral arguments. So with that, let's get the ball rolling. Cases that make it all the way to the Supreme Court are cases that have either come from federal courts of appeal or from Supreme Courts at the state level. It's important to point out that the only time the Supreme Court will hear a case from a state Supreme Court is if that state case dealt in some way, shape, or form with a federal issue. If it's a state issue, the Supreme Court will ignore that particular case. Every year, the Supreme Court gets thousands of cases sent to it from various parties who have appealed decisions made by lower courts. And those petitions are asking the court to grant what's called a writ of certiorari, or again, that is a cert, C-E-R-T, for short. And if the court grants cert, what it means is they have agreed to consider that case. Every year, the Supreme Court's term starts on the first Monday in October, and it goes until about June when they release most of the decisions in the cases that they agreed to hear. But when they first start meeting in October, they don't start hearing cases right away. They start to meet along with their staffs and decide on what cases they should decide to hear in that particular term, or what cases should receive a writ of cert. They receive thousands of cases every year, on average of 7,000 to 8,000 according to most sources. And on an average year, or in an average year I should say, the court grants cert to between 75 and 100 cases. And we'll talk in just a minute about what kind of cases are the ones that actually get cert in the first place. But if a case is granted cert, they're placed on the court's docket or schedule of cases to be heard and considered, and oral arguments are scheduled. The way the Supreme Court works, you don't have witnesses, so to speak, but you do have lawyers that come before the court and have 30 minutes to argue their side, and that'll be set up for a particular day. The justices will hear the arguments, and then they'll eventually down the road render their decision. Now, if you're one of my students, we'll be talking about how the decision actually is rendered later on in this unit. But again, only about 100 cases a year they decide to hear. The Supreme Court certainly doesn't have the time to hear every case that comes before it, so they have to make decisions. They rely very heavily on precedent. So if a case that is petitioned to the Supreme Court has really already been decided by the Supreme Court before, the odds are pretty slim they're going to decide to hear that case again. That's because the court relies on what we call stare decisis, which literally translates from Latin as let the decision stand. So the idea is the court stands behind its prior decisions, and it really takes something fairly extraordinary to get the Supreme Court to reverse a decision it's previously made. Now, it has happened throughout history on several occasions. Most notably, if you're one of my students, you remember that Brown versus Board of Education in 1954 overturned 1896's Plessy versus Ferguson. Gideon versus Wainwright, the case about the man having the right to an attorney even if he was indigent, in a state case, that overturned a case from 1942 called Betts versus Brady. So cases can be overturned. The cases that typically get certiorari are the cases where the lower courts made a decision that breaks with the Supreme Court's precedent. So the Supreme Court has to hear that case and decide, okay, we're going to stay with precedent or we're going to reverse ourselves. If a case raises a new legitimate constitutional question, something the Supreme Court maybe hasn't considered before, the healthcare cases from 2012 will be an example of that. If two different appeals courts issue different rulings on the same issue, the Supreme Court may look to clarify that particular case, or if courts from two states have ruled in a different manner on a federal issue. So again, the justices and their clerks hear these cases or read these cases and review them, and if 4 of the 9 justices agree that a case should be considered, it will be granted cert, and that's referred to as the rule of 4. That's all for today. Be sure to ask your teacher if you have any questions. Cheers.